Hello everyone, I hope you all are doing well. Let's see let's continue from what we had seen in the previous session, the deductions or the details of some of the deductions which are discussed in section 18 as an authorized deduction in the code on wages. So we have up till now seen or discussed section 18, 19, 20 and 21 regarding the deduction. There are three more sections in the same line, which is section 22, 23 and 24. Section 22 discusses the deductions for the services rendered. It says that if an employer has rendered some services to the employee, maybe for example some house accommodation, amenity or any other service, could be service of providing electricity or medical health is insured by having a dispensary located in the workforce, or sorry, not the workforce, but near the residence of the workers, the employees, or any other service which is being provided by the employer. There could be some deductions for such services which are being supplied, maybe an internet facility which is being given to the worker, or any other facility which is being services which are being supplied by the employer to employee. So it can be, that it could be considered as one of the one of the thing on which the deduction can be made by the employer, and would be considered as a part of the authorized deduction. Again, I would once again remind you of the definition of a wage, which says that it doesn't include house accommodation and amenity, right? So what it says, the definition of wage says that wage doesn't include house accommodation facility or the amenities or services which are being supplied by the employer. So do not get confused that it generalizes all the cases. What it says, the definition of wage says that the house accommodation facility or the services which are being supplied by the employer to the employee, and which are listed or which are specified by the appropriate government, that on these services or this services shall not be considered as a part of wage, would not be considered as a part of the wage. Right. Now here we are talking about the deductions. The deductions could be, or could be from the wages for such services which are being supplied to the worker. So if the employer has provided the house accommodation facility or any other service as we have just discussed, then there could be a deduction for the amount of such house accommodation facility or the services which are being rendered by the employer to the employee. However, there is a condition for the same, and the condition precedent here is that the employer has to, and has to take this in in an accepted form from the employee. That means that the employee should have accepted such house accommodation facility or such supply of the services. And if there is no acceptance from the side of an employee of such services or of such supply of the facility, that cannot be imposition of any deduction, or there cannot be any deduction from the wages of such employee. So for example, if there is a rule that the employer in a particular company, employer is providing residence right within the premises of the workforce, and all the employees are are staying there, and if there is one employee who is not actually requiring such house accommodation facility, who's living nearby the premises, then such person who's not living in that particular premises, or who has not actually accepted such supply of the facility, there cannot be any deduction from the wages of such employee for this particular, or in under this particular head, that that such amenities or facilities are being rendered by the employer to the employee. And employer cannot say that I'm keeping a room or a house booked for you, and I have kept it booked for you or in your name, by virtue of you being an employee of the company, and you will have to pay for that amenity. No, that cannot be done. If there shall be an acceptance, an explicit acceptance from the side of the employee for such services which are being rendered by the employer, and after that, if the employer is deducting any amount from the wages of the employee for such facilities so supplied to the employee, it would be considered as a authorized deduction. Further, what section 22 says, like other section, that the value of such a deduction shall not exceed the actual value of such house accommodation or the amenity or a service so supplied. So if I am supplying you a 2 GB internet free for a month, and if the value of the same is 600 rupees, I cannot charge you for 1000 rupees. So the employers cannot say that this facility, broadband facility, or the facility of this house accommodation, or maybe what do you call maybe the laundry facility within the workforce, within the premises for the workers residing within the premises, would have more, larger or more charges than the actual value of the same. That shall not also be done by the employer. It should be, the deduction should be only of the amount of the value of such services which are being supplied by the employer to the employee, and all this shall be subject to the conditions which are being imposed by the appropriate government. Why? See, here section 22 clearly mentioned that this is subject to the imposition of the conditions from the appropriate government. And the same thing we had seen in the definition of a wage, that a house accommodation or the facilities or amenities will not be considered or may not be considered as a part of a wage in case when the appropriate government has explicitly or clearly stated that this should not be considered as a part of the wage. So if there is any such notification, it won't be considered as a part of a wage, and may not be considered as a may be considered as an authorized deduction. But if in case the appropriate government states that there are some residential or the what do you call schemes for the residents of the workers, then, and if the government is stating charging no fees for such services so supplied, or are mandating no deductions to the employers also for such workers or such employees, then there cannot be any deductions with that particular regard if the appropriate government has notified any such thing as per section 22. Next is section 23, which discusses deductions for the recovery of advances. If yes, definitely employees do require advances, advance money, advance supply of some facilities, food, or food, anything, right? Now then in that case, section 23 states that there can be a deduction for such advanced money or such advances which are being made by the employer in the favor of the employees. So section 23 says that any advance of the money which is being given to an employee before the employment begins shall be made from the first payment of the wages. What section 23 says is that if any employee has taken an advance from the money of any advance money is being taken by an employer, by any employee from the employer before the beginning of the employment, right? For example, if the employee has asked to the employer, or has requested to the employer that I do not have money to shift or stay here or rent a house in this particular area, we would require some advances before I join at the workforce. So such advances of the money which are being given by the employer to the employee, it shall be deducted, or deduction for such advancement shall be made from the first payment of the wages only. There cannot employer cannot say कि चलो भाई ठीक है पहले फर्स्ट जो wages है उसमें से नहीं डिडक्ट करना है, and then let me deduct the wages from the second second month's wages, no, that shall not be done. From the first wages or the first payment of the wages only such a deduction shall be made. Now again, if you can recollect section 18, which says that the total amount of the deduction shall not be more than 50% of the wages of an employee. That means even this section 23, which talks about the deduction of an advancement, if the, for example, the wages or the remuneration of the employee is 20,000 and 50% of the same is 10,000 rupees, right? So if and in case if the employer has advanced 15,000 rupees to that employee before that employee joined the workforce or joined at the workforce, and then in that case this implementation, if execution of this section 18, if you see section 18 says that not more than 50% shall be deducted or shall not be a deduction. So what will happen? Should the employer suffer from the loss? No. Then again section 18 says that any other the thing amount or the amount in excess of the 50% shall be recovered in a way which is specified or which is prescribed by the appropriate government or the authority time and again. So this appropriate government or the authorities are duty bound to maintain or make such rules and regulations, and in accordance with the same only the employers can deduct the amount of such advances or the such excess of the advances from the employees. So as far as the application of this section is concerned, section 23 clearly states that any money which is being advanced to the employee before the joining or before his joining, then in that case from the first payment of the wages such money shall be recovered or such reductions shall be made. Again this section says that there cannot be a recovery of advances given for the traveling expenses. If in case the employer has also advanced some amount, maybe a person is not from the same region and needs some money for transferring from one region to the other region, right, or from one place to other place, then such traveling amount or such expenses for the travel shall not be considered as a deduction or shall not be considered as an advance itself, and such advances cannot be deducted under this particular section. So section 23 talks only about the advanced money and no other way of and it clearly or explicitly says that recovery of any advances towards the traveling expenses or the conveyance, you can say, right, charge expenses shall not be made under this particular head. And further all such recovery of advance money or any wages which are being done by the employer to the employee shall be governed by the or shall be subject to the conditions which are settled by the appropriate government through different notices. So that also has to be within the notifications or within the authority, the rules which are being prescribed by the authorities or the appropriate government with this regard. Next is section 24, which discusses deductions for the recovery of loans. If there are any loans which are being taken by the employees, of course the payment towards such loans can be paid directly from the wages or can be deducted directly from the wages. So section 24 says that if in case there are any deductions for the recovery of the loans, it shall be made as prescribed and be regulated or be regulate to the extent to which such loans may be granted and the rate of interest payable. So whatever the regulations or whatever the rules are framed for such while granting such loans, that has to be adhered, and in accordance with that only such deductions can be made. So if the loans are granted with certain conditions that okay, your from your wages this particular amount will be deducted by the employer, then that particular amount shall be deducted by the employer from the employees under this particular aid. So all the interest and all the installments in which were agreed on or which were or to which or with the condition of which the loans are granted, that has to be followed, and in accordance with that only the deductions can be made under this particular head, section 24. With this we have covered the deduction part and the mode and fixation of the wages and all the allied provisions. In the next sessions we shall see the claims and the offenses and penalties part of the of both concept of minimum wages as well as payment of wages. Till then, take care of yourself, your family, and thank you for watching this particular video and learning through this particular mode of or the virtual class. I hope you all are taking care of yourself, are cautious, are understanding the grievous nature of the pandemic and of COVID, due to this COVID-19, and are taking all the care, are remaining at home, are following the news, are following all the regulations which are set by the government. Please take care of yourself. Please invest your time in conducting some research, in developing your scholarships, and take care of yourself. Thank you.